Am I live?
Yes, you're live, Your Honor.
Okay. Okay, let's go ahead and proceed on this. We're going on the record on, cause number DC 1916673 JTJ Solutions LLC, formerly known as FTGU Medical Consulting LLC versus Eli Global LLC. Counsel, make your appearances.
Good afternoon, Your Honor.
Plaintiff goes first.
Good afternoon, Your Honor. This is Andy Ryan for the plaintiff, JTJ Solutions.
And this is Leah Lanier on behalf of the defendant, Eli Global LLC.
All right, and it's Eli Global's motion to compel, is that correct?
Yes, Your Honor.
Okay, let's go ahead and proceed.
As you mentioned, there were two motions pending before the court, the agreed motion for continuance and the motion to compel. Should I go ahead and just start with the motion to compel since that's
Probably, yeah.
Okay, Eli Global filed the motion to compel, requesting three different grounds for relief. Eli Global requested a motion to compel a privilege log, a motion to compel production of documents evidencing attorney's fees sought by the plaintiff, and also for depositions of three key witnesses. On Friday, plaintiffs responded to the motion to compel and provided deposition dates for those three witnesses, and also provided documents evidencing attorney's fees. And so there's one issue that remains pending, and it's the privilege log. For background, this is a suit on a promissory note. Defendant asserts that the promissory note is not valid because it's not supported by adequate consideration. There's no consideration on the face of the note, and the defendant maintains that they received nothing in exchange for executing the note. On the other hand, argues that the note is supported by consideration because plaintiff would not have entered into a separate purchase agreement with a third party, but for the note. Defendant served discovery requests in January, requesting documents relevant to the issue of consideration. Specifically, defendants requested all documents and communications related to plaintiff's decision to enter into the note and also the purchase agreement. Plaintiff has failed to produce any documents relevant to these requests, haven't produced any documents at all dated before the execution of the note or the asset purchase agreement. They responded that there are some relevant documents, but all of those documents are protected by privilege. Defendant requested a privilege log. Plaintiffs refused that request. And now we're here requesting that the court compel a privilege log.
Mr. Ryan?
Well, Your Honor, let me start off with what I think is the big part of the party's dispute. Ms. Lanier is correct that the key issue is whether or not there's consideration to support this note. The court heard summary judgment arguments on that question on either May 17th or 18th, and the parties have been awaiting a ruling on that issue. That kind of gets into this privilege log question, because what they're looking for are non-privileged materials that JTJ Solutions would have. And in response, we told them two things. One is because the transaction, the underlying transaction of which the note was a part, is an asset sale, we no longer have access to any communications that we had at the time that we were FTGU Medical Consulting. That's now all those servers, devices, emails, etc. Those are all in the possession of the defendant, Eli Global. So in raising the privilege objection, what we did was identify that there may be documents that are in the possession of the transactional lawyers for the plaintiff But other than documents that were shared with Eli Global as part of that transaction process, which of course Eli Global has access to, excuse me, we contend that the balance of those documents are presumptively privileged. And so the reason why we don't need to do a privilege log here is kind of akin to the reason you wouldn't need to do one with litigation counsel. If the only thing that we could potentially be withholding are internal correspondence between JTJ and its transactional lawyers, and there's no reason to think that those communications aren't privileged, then what the defendant is effectively asking us to do is to go to our lawyers, obtain a copy of our client file, and then produce a privilege log on documents that would be presumptively privileged. Because anything that was shared with Eli Global already has. Now, even though we think that request is a little outside the bounds of what Rule 193 requires, Rule 193 does not require a particularity item by item listing of what potentially could be included. It only requires identifying by group of item or category and the basis of the privilege. And we included that in response to our motion to compel. Essentially, the only items that we believe that we would be withholding if we were forced to go and get this information from our former transactional lawyers would be internal email correspondence between JTJ's principals and their counsel, or internal drafts of transaction documents that may not have been sent to Eli Global, all of which are presumptively privileged. There's no reason why those communications wouldn't be privileged. So we think that it doesn't make sense for the court to order us to produce any more of detailed information about these documents than we've already given. But I do agree with Ms. Lanier that this is really the only issue left, whether or not the court's going to order us to go to our former lawyers, compel our client file be turned over, and then log anything that was just internal communications between JTJ and its lawyers.
Okay, response?
Yes. Eli Global is not looking for internal communications between JTJ and its counsel. What we're searching for are communications with third parties, communications between JTJ's directors, things of that nature that aren't privileged. And we just can't tell at this point what would be privileged and what's not, because we haven't seen any of the documents. We haven't gotten a detailed privilege log. If JTJ can represent that there are no documents out there besides these internal communications and internal attorney work product, then they need to say that and we can move on.
Okay, let me just do a couple of things. I apologize. I thought I'd already ruled on this quite a while ago. I am granting the partial summary judgment on this. I apologize for any inconvenience. I didn't realize I hadn't done that. And so that'll be granted. I'm going to deny the motion to compel the privilege log at this point. It sounds like you need to make a statement. The only thing that's available is core work product. Is that right, Mr. Ryan?
Yes, Your Honor, though in fairness to Ms. Lanier, I think that she's right that there is one place where I've fallen down on the job. I need to make sure there's not potentially a non-privileged third party that there could have been communications with,
okay,
such as an FA that was, or financial advisor.
Then I'll go ahead and grant the motion to compel the privilege log. So now let's talk about, so with the summary judgment granted, we have the issue of damages, obviously, as well as any counterclaims. Or do you have any counterclaims at this point, Mr. Ryan?
Well, we're the plaintiff, Your Honor. So the counterclaim that's been asserted.
I'm sorry, Ms. Lanier, do you have any counterclaims?
We do have a counterclaim asserted.
Okay. So the summary judgment is granted. But that doesn't affect your counterclaims or affirmative defenses, and we still need to decide the issue of damages. Seems like what do we still need to do on this case? Is this still a non-jury case?
You know, Your Honor, I pardon me, but I don't remember whether or not we filed a jury demand. Give me one moment, please.
Sure. Rhonda, can you tell if they filed the jury demand? It's still in the non-jury docket.
we included a jury demand, Your Honor. Perhaps we maybe we didn't pay the fee, which is why it's showing up on the non-jury docket.
Was a jury fee paid? Rhonda? Rhonda, are you there? Okay, sorry. She'll text me in a second. She's usually really good about that. So, Rhonda, just let me know if a jury fee was paid. So let me kind of tell you what I've given this speech many times. These brand new interns have already heard it twice, I think. So obviously we all know that the courts are facing kind of somewhat of a crisis, which is we have not been able to conduct any jury trials for 5 months. It looks like it's going to be at least a month and a half more, but probably much more than that. And so what we're facing is a situation where we need to try as many cases as we can right now, because we have all these other cases that are going to be coming down the pike. And so the example I give, Ms. Lanier, do you watch, or Mr. Ryan, do either of you watch Grey's Anatomy?
I have in the past.
You have in the past. Mr. Ryan, have you watched Grey's Anatomy?
This is on the record, Your Honor, so I'm going to have to say I'm sorry I can't answer the question.
Wow, I didn't know it's a good show anyway. And in Grey's Anatomy, they'll always have different disasters, and they'll have plane wrecks and train wrecks and all sorts of other stuff. And the doctors are waiting, in anticipation for all of these patients to come in. And the best example I can give is we're kind of in that waiting period, because once this logjam is ended and we can start trying jury cases, we're going to be swamped and we won't be able to do anything else. And so for the cases, so your case is kind of like, if you haven't paid a jury fee, kind of like a person who's walked into the emergency room while they're waiting for all of these cases to come, with a broken leg, and says, wait, I need to wait. My wife and daughter need to come and help me and be with me while you repair my leg. And the doctors have to say, look, we have to deal with this now before this flood of new cases come in. And that's kind of where we are with this. And so if you've requested a jury, great, we'll go ahead and move you. You'll probably get tried sometime late next year. But if you haven't requested a jury, I'm going to kind of keep you to it and try to get this case tried as quickly as possible. So, and it's not that I'm trying to pick on you or be mean. It's just I've got to look at the overall court docket. And so, does that make sense to y'all?
Yes, Your Honor.
Yes, Your Honor.
So, and it doesn't seem like there's that much that needs to be done on this case. What still needs to be done?
Your Honor, I don't think there's very much. The amount of the loan payment that's left, we would need to calculate interest, have an updated interest calculation, though I don't imagine that would be in dispute. And then potentially attorney's fees, discovery. And then there are some other affirmative defenses that Eli Global has asserted. Now, their counterclaim is that because the contract wasn't supported by consideration, the 2 prior payments made under the note would need to be returned. I would think the court summary judgment order would kind of dispense with those counterclaims as well, but we may need to figure out how those two interact.
I mean, they're not seeking damages, consequential damages for failure to make the third payment. Or is that not part of this? We're only seeking, so there were 3 payments on the note. We're seeking the third payment plus interest. The defense argument, the counterclaim, was that since the transaction was not supported by consideration, plaintiff should have to return the first 2 payments. So it would be that we don't get paid the third note and have to repay back the first 2 note payments. That seems to be dispensed with because of the court's ruling on the summary judgment motion. But wait a minute. Maybe I was looking at the wrong thing. So in this case, the plaintiff was suing because they made 2 payments under the note, correct?
The plaintiff was suing because there was a note where 3 payments were required to be made by the defendant. 2 payments were made. The third payment was not made. the suit was filed to recover the third payment from the defendant.
To be paid the third payment.
Yes.
Okay.
And then the defendant asserted the consideration defenses as affirmative defenses and as the basis for a counterclaim, arguing that because the contract was not supported by consideration, money that had previously been paid under the note would have to be returned. So effectively, we were suing to recover the third payment from the defendant, and the defendant is countersuing to recover the first two payments from the plaintiff.
Okay. I'm sorry, this is why I should rule on these things more quickly. I had it confused. So there was a plaintiff's motion. Was there also a defendant's motion for summary judgment?
No, Your Honor, just a response.
Okay.
And I was actually on maternity leave when that all went down.
Okay. All right, I apologize. I was reading back through this too quickly. I'm going to go ahead and deny the motion for summary judgment. I thought that it was sorry. That was my mistake. So yeah, we're denying the summary judgment. So why has the defendant not moved for summary judgment on this, I guess?
You're on.
We're drafting it. We are going to. We were going to wait until we had taken depositions, but that hasn't happened yet.
Because you guys you've lent them $670,000 or so, and they haven't paid your client back, right?
No.
What am I missing here?
All right. Yeah, Your Honor, let me try to go back to the beginning.
Okay.
So JTJ is a medical billing company.
Right.
JTJ had a business that it sold to an affiliate of Eli Global.
Okay.
That was an asset purchase agreement. The asset purchase agreement included upfront cash consideration, and then it included a note given by Eli Global to JTJ as part of that purchase price. That note required annual payments of effectively $340,000 because it was a total of $1 million note plus some interest.
That Eli Global was paying to the plaintiff.
Correct.
Okay.
So
the plaintiff's predecessor.
To the plaintiff. There is the plaintiff just changed its name after the transaction. So it's the same company, just changed the name because as part of the asset purchase, Eli Global got the IP, including the name of the business. So what the transaction has an effective date in 2016. The loan calls for annual payments. The 2017 payment is made by Eli Global to the plaintiff. The 2018 payment is made by Eli
purchase
Global.
purchase this.
Yes, there's part of the purchase price. Yes, Your Honor. So the 2017 and 2018 payments are made. The 2019 payment is not made. 2019 payment was due in September of 2019. We moved for summary judgment
saying that they need to pay the third payment.
Yes, except it was a partial motion, so it left open damages and defenses, but essentially what it said is we have an effective agreement and you're in breach. And the response to that was that the note was not supported by consideration because the sale from JTJ was actually to an Eli Global affiliate. And we said, well, that doesn't matter because you can have a transaction where—
I get it. Okay. All right. So yeah, I meant to say that I would grant the summary judgment on that. I misunderstood. Okay. So I'll go ahead and get the order out on that. So bottom line is, when can we get this case tried? Could we do it in September? You need October? Kind of give me a time frame.
Well, the current trial setting is October 6th.
Okay. Well, why can't we get it done by then?
We haven't been able to take any depositions.
Okay. But you guys have agreed on dates for the deposition.
Yes. Or, well, we've got potential dates and we're hoping that at least one of those works out.
Okay. And when are those dates?
September, is that correct?
The second and third week of September, Your Honor, we gave 3 dates, I believe, for each witness, and we're waiting to hear back from Eli Global which one works.
Okay. So, and then what else still needs to be done?
I think if the summary judgment motion is granted, Your Honor, I think all that's left is for Eli Global to figure out if they have any other affirmative defenses they want to proceed on. And then from there, we would just have a trial. The damages number is not really in dispute. We'd have a trial about attorney's fees.
Is that right?
I think that's.
Are these depositions even necessary at this point?
It's hard to say without seeing exactly what the order is going to be on the summary judgment.
Okay.
Your Honor, can I suggest something, please?
Yeah.
What I might suggest is that we've always thought that if the court made the ruling that it's now going to make, that would probably resolve the need for a trial for the precise reasons that we've been talking about just now. I don't know if you'd want to set us for a status conference like a week out and we can tell you where we are, but we do have
a week out from trial.
I was going to say a week from now or 2 weeks from now, but just to get back to you about, is there really anything left to do in light of the order?
I'm fine with that. Okay. Worried that Rhonda. Okay, so how about let's do a status conference in 2 weeks from today at 10 o'clock.
That works for the plaintiff, Your Honor.
Checking my calendar, Your Honor. So that would be the 7th at 10 o'clock?
Oh, wait a minute. Is that Labor Day?
That is Labor Day, yes.
Okay. How about the 4th at 11 o'clock, which is a Friday?
Yes, that would work for me.
Yes, Your Honor. September 4th at 11 works for the plaintiff.
Rhonda, are you there? Did you get that? I'm a little worried she's not there. So, Mr. Ryan, go ahead, contact my court coordinator, Rhonda, and just let her know that I set a status conference at 11 o'clock on the 4th.
Yes, Your Honor.
She's back. Rhonda, I set a status conference on this case for 4 o'clock. It's the, I don't remember the cause number on it. 1916673 JTJ Solutions versus Global. So September 4th at 11 o'clock. Okay, she got it. All right, guys, we'll get you an order out today. And I'll also need an order. Did you submit an order on the motion to compel?
I believe so. I will submit. If I have not, I will submit one.
Go ahead and email Rhonda that order, and we'll go from there. Oh, and I don't know that we discussed how much time you, Mr. Ryan, had to provide a privilege log.
So, Your Honor, we still may not be providing one in light of Ms. Lanier's statement that they're not looking to get into internal communications. But if we do have to provide one, I've got to go to their corporate lawyer and demand turnover of the client file, which I don't know how long that would take.
Well, you had said that there may be a communication with a third party, right?
I don't know whether or not that's true. What I was trying to make clear is that I need to find out if there is such a third party. I don't believe there is, but I don't know. And Ms. Lanier was right to point out I need to prove that. So what I might suggest is, can we address the date of when to turn over the privilege log at the status conference next week if we haven't worked it out with the parties by then? Because I may have an answer that says there's not going to need to be a privilege log because there's not a third party within the next couple of days.
I would agree to that.
Okay, well, just get me an order.
Yes, Your Honor.
All right, anything else, guys?
Not for plaintiff, Your Honor.
Nothing from the defendant.
All right, thank you.
Thank you, Your Honor.
Thank you.
Okay, so I guess I need to bring these people back. Give me a second. I need to go grab some orders. I'll be right back, guys. And feel free to chat amongst yourselves. Julian, I don't know if you've met everybody.
I have so many questions. Okay, what is a privilege log? Like, am I supposed to know what a privilege log is?
We're still live on YouTube.
Oh, well, they will know my questions too.
I don't know. I was just thinking, well, that's okay. I don't want to. Privilege law. Is that just like
Log? Like,
It's a
what is this
document
log?
that describes all the documents and / or information that a party is claiming to be privileged for any number of reasons.
Okay,
so?
so that's
So
like
it's
part of the
self-explanatory.
Okay. Okay. Well then, I overthought that way too hard. And then the other one, can you do that if you say that you didn't like give consideration? Is it possible for you to go ahead and like get a instead of, I guess, requesting all the money that you paid towards the loan back? I didn't know that you could even do that. I've never even heard of people doing that. Like that, I don't know, something like that just sounds weird to me.
Well, they're just saying the contract's void, right?
And then all the money that they paid towards the loan, they want the money back. Can you do that? I didn't know you could do that. I feel like once you start paying, that's like you agreeing. I don't know though.
I mean, I guess so.
Where's Valencia when we need him?
Got the chills. Oh,
I don't think you could do that. What?
I mean, I don't know if he's going to be successful, but sounds like a no. But what do I know? So, Julian, you go to SMU?
I do.
You do? Okay. Are you like a 2L or a
I'm
3L?
yeah, just started my second year.
Okay, yeah, same with us. So,
UNT, both of you guys, right?
Yes.
yep. Where are you from?
I've lived here my entire life. I'm from Carrollton.
Dallas. Okay. Where'd you go to school?
High school?
No,
or
you always
undergrad?
both.
High school, Carrollton, and undergrad was at UT Dallas.
Oh, okay. Man, you just really love Dallas. Can't stay away.
It worked.
But I brought my office chair in here. But I'm in my bathroom right now because I don't have good Wi-Fi anywhere in my apartment. So
Fair. I would not have even thought that that was the bathroom. I kept on thinking that the bathroom was behind you because there's a door. And
where does it look like I am right now? It's like I'm totally in a bathroom right now.
Just some room in the house.
Good.
Yeah, just
Okay.
a room.
Good deal. Good deal. That's my goal. All right.
Judge Hoffman,
Yeah.
you might want to turn off the YouTube.
Oh, thank you.